This is a Harlan Institute FantasyCast for Hosanna-Tabor Church and School versus Equal Employment Opportunity Commission. This case concerns a church's First Amendment right to free exercise of religion, and how that right relates to the church's ability to be sued by former employees who claim discrimination. This case arose when Cheryl Perrick, a teacher at Hosanna-Tabor Evangelical Lutheran School, went on a medical leave of absence after being diagnosed with narcolepsy. While on leave, Perrick was promised that she would be able to retain her job. However, when the school's administrators and church congregation began to fear that Perrick would be unable to properly care for the children given her medical condition, they voted to ask her to resign. Perrick refused to step down from her position, but when she returned to school after her medical leave, she was told that her position had been filled and she had officially been terminated. Perrick filed a complaint with the Equal Employment Opportunity Commission, and together they brought a lawsuit against the school for unlawful discrimination under the Americans with Disabilities Act. The District Court for the Eastern District of Michigan dismissed the case, citing something called the ministerial exception. This exception is based on case law stating that courts cannot interfere with matters of church governance, such as the hiring and firing of religious leaders, because these decisions fall under the church's First Amendment right to free exercise of religion. Because courts cannot intervene in such personnel disputes, it is generally accepted that former employees of religious institutions cannot sue their employer under federal discrimination law. The Sixth Circuit Court of Appeals reversed the decision, holding that while the ministerial exception is valid, it should not apply to a teacher like Perrick. Judge Eric Clay reasoned that, while Perrick did work for a religious school, her role at the school was primarily non-religious, and her duties were mostly secular. Therefore, she should not be barred by the ministerial exception. The Supreme Court agreed to hear the case and to consider whether Perrick, as a teacher at a religious school who performed a mix of religious and secular duties, should be prohibited from suing her former employer for discrimination. Thank you for listening to this FantasyCast. For more information, please visit harlaninstitute.org or fantasyscotus.org.